Welcome back to The Explainer. So, have you ever actually stopped to wonder how a simple, everyday promise magically transforms into a legally binding contract? Like, what is the actual invisible glue that makes an agreement hold up in a court of law? Well, today, we're going to unpack the exact anatomy of a deal. We're zeroing in on one of the absolute most fundamental concepts in the Indian Contract Act of 1872, consideration.
Okay, let's just quickly look at our roadmap for today. We're going to cover the price of a promise, acts, promises, and forbearance, past, present, and future consideration, whether value actually matters, exceptions to the rule, and finally, wrap up with the privity principle. Let's get right into it.
Section 1, the price of a promise, which is really the foundational philosophy of contract law. No consideration, no contract. It's a bold common law rule, right? Originating in English common law, the core principle is actually incredibly simple. A promise without any real legal value given in return is, generally speaking, just a gratuitous promise. Sure, it's a very nice gesture, but legally, totally unenforceable. You see, to prevent endless, frivolous litigation and to prove that both parties have serious intent, the law demands that a literal price be paid for a promise.
Now, if we look at the formal definition from Section 2D of the Indian Contract Act, okay, I know, it looks incredibly dense, but break it down, and it basically just means consideration is something given in return for a promise, and it absolutely must move at the desire of the promisor. In fact, in the famous case Curry v. Misa, consideration was brilliantly defined as a benefit to one party or a detriment to another. Ultimately, this whole concept is here to ensure reciprocity. Both parties have to bring something of real, lawful value to the table to create that commercial certainty we all rely on.
Moving on to Section 2, acts, promises, and forbearance. Basically, the three shapes of consideration.
So the very first shape is an act, and this is exactly what it sounds like. You're actively doing something lawful at the promisor's desire. To put that in everyday terms, it's like actively delivering a batch of inventory to a store, rendering a professional service, or, physically constructing a building in exchange for payment. You're performing a concrete action that holds clear legal value.
The second shape is forbearance, and honestly, I find this one absolutely fascinating. Forbearance basically means abstaining from doing something. You are deliberately surrendering a legal right, and the law actually recognizes that exact surrender as valuable consideration. A really great everyday analogy here is a creditor who legally agrees not to sue a debtor immediately. By actively holding back from filing that lawsuit, they are offering forbearance. This exact principle was famously highlighted in the classic case, Hamer versus Sidway, where just refraining from exercising legal rights constituted perfectly valid consideration.
And the third shape is simply a promise, literally just exchanging one promise for another promise. This forms the entire bedrock of bilateral contracts. Just imagine a standard mutual promise in a sale. One party promises to deliver goods next week, and the other party promises to pay the invoice upon delivery. Simple, right? As emphasized in the famous Dunlop pneumatic tire co case, these reciprocal promises act as absolutely perfect contractual consideration.
Section 3. Past, present, and future. The time-traveling nature of consideration. Let's just walk through this timeline together. Think about it. If you run down to a store and buy a coffee with cash, the promise and the consideration move at the exact same time. That's present consideration. Now, if you sign a massive commercial agreement to supply parts next month for a huge payout next year, that's future or executory consideration, because the obligations are happening down the line. But what if you voluntarily do a massive favor, perform a service for someone at their request, and later on they promise to pay you for it? Well, that right there is past consideration.
Now here is where things get really interesting. Look at the active contrast between these legal systems. Under English law, like we saw in Ross Corll over Thomas, past consideration is generally completely invalid. It just doesn't count. But the Indian Contract Act, it is way broader and far more flexible. As established in cases like Sindha Sri Gampa Singh G v. Abraham, past consideration is perfectly valid in India, provided the act was originally done at the promisor's request. This much broader approach promotes a massive amount of commercial convenience.
Section 4. Does value actually matter? Let's talk about the adequacy of consideration.
I actually want you to think about this for a second. If you, let's say, agree to sell a luxury car to a friend for just 100 rupees, can you later back out and claim the whole contract is void just because the deal wasn't fair? Like, does a contract literally have to be a perfectly equal exchange of economic value to hold up in court? What do you think?
Well, the crucial point here is that the law firmly respects your freedom of contract. According to Explanation 2 to Section 25, an agreement is absolutely not void merely because the consideration is inadequate. As long as the consideration is legally recognized, even if it's completely nominal, like in Thomas v. Thomas, the courts are generally not going to interfere in your commercial wisdom. But, hey, there is a catch. Gross inadequacy might be used as evidence to prove that your consent wasn't actually free. It might hint at fraud, coercion, or undue influence, which is exactly what we saw in Mano Singh v. Umadot Pandey. But inadequacy all on its own, it's not a deal breaker.
Section 5. Exceptions to the rule, or basically, when no consideration, no contract doesn't actually apply.
Let's quickly walk through these carve-outs where gratuitous promises are actually fully enforceable. First up, agreements made out of natural love and affection. These are valid, but they have to be in writing, registered, and between near relatives, a principle discussed heavily in Rajluki Dabi v. Bhutnath Mukherjee. Second, think about a promise to compensate someone for past voluntary services. Third, you've got a written and signed promise to pay a time-barred debt. Fourth on the list, setting up an agency actually requires zero consideration under Section 185. And finally, completed gifts, those remain perfectly valid. Really, these exceptions just exist to protect honest, non-commercial arrangements and clear moral obligations.
And finally, Section 6, the privity principle, also known as the VIP list of contract enforcement.
This brings us to a really brilliant illustration of the privity of contract doctrine. Imagine Party A and Party B sit down and make a legally binding contract that, down the line, ultimately benefits Party C. Now, if Party A suddenly breaks that promise, can Party C sue? Generally speaking, absolutely not. This rule was firmly established in the landmark English case Tweddle v. Atkinson. Basically, a stranger to a contract cannot sue. This doctrine is there to maintain contractual certainty, protect the absolute freedom of the contracting parties, and honestly to prevent random outsiders from launching a multitude of legal claims.
But just like the rule of consideration itself, this rigid privity rule has equitable exceptions under Indian law to prevent severe injustice. For instance, in a trust, the beneficiary can totally sue the trustee, even though they didn't sign the original trust deed. Similarly, third-party beneficiaries can enforce family settlements, which was beautifully recognized in the famous case Khwaja Muhammad Khan versus Husseini Begum. Other exceptions cover scenarios involving acknowledgement of liability, agency, charges on property, and assigned rights. Basically, the law steps in to protect beneficial interests when strict, rigid rules would just cause unfair harm.
And that actually brings us right to the end of today's explainer. We've seen exactly how the Indian Contract Act demands consideration to ensure serious reciprocal business dealings, yet it carves out these brilliant human exceptions for love, past services, and family. It really begs an incredible question. By balancing these strict rules of enforcement with these equitable human exceptions, does contract law ultimately prioritize cold commercial certainty or fundamental fairness? It is a delicate, fascinating balance that literally keeps the wheels of our society turning. Thanks so much for joining me on this deep dive into the anatomy of a deal. Keep questioning and keep learning.